Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
Welcome to this, our weekly weekend venue broadcast. My name is Jim Santelle, and I am your host this hour and next hour as well for our broadcast here on the broadcast stations of Civic Media. We call our program Amicus, a law review. This is our 105th broadcast since we first went on the air in the networks of Civic Media in the summer of 2022. Delighted and honored to have you with me once again this weekend for our review of all things legal, all things rule of law, all things justice related. We take our name, as you now well know, amicus, from a legal term. It is derived from the Latin. It describes a friend. Ami is inside amicus. It's an individual, an organization that somehow assists in understanding, appreciation, assessment of some relevant issues or some other challenges, some questions that need resolution to be resolved by a court, for example, a judge, or some other entity that needs information, needs insight and perspective for that decision-making process. That's what gives animation and life to our program. And again, part of that program is your involvement. In our second hour on this weekend broadcast, we're specifically inviting your questions, your inquiries about the subject matter of this broadcast, but also our previous broadcasts, including those of last weekend. Last weekend, I spent virtually all hours, 2 of them on Saturday, 2 of them on Sunday, all broadcasting about what the United States Supreme Court, this major time in our nation's history when the Supreme Court issues all of its most significant rulings in May, June, and yes, in July, the first day of July. We spent time last weekend talking about these 10 major cases decided by the Supreme Court in just the previous week. And because of our attention, necessarily the content, the substance of those, decided not to take callers in our last broadcast. This weekend, just the opposite, inviting very much your phone calls and especially your questions and your inquiries about the subject matter, which, yes, once again, is going to be about the United States Supreme Court. That number is 844-967-2789, 844-967-2789. My wonderful producer Max also reminds me that you can drop a note in the Civic Media app. Be in touch with us that way. Send your question, your inquiry to Max or me through that process, and we will get to those in our second hour on our weekend broadcast because there are a lot of questions. There are a lot of things that you may want to follow up with me and others when it comes to understanding what our Supreme Court has just done. Of course, most important, this broadcast, we're going to be spending some huge amount of time talking about this major case involving Donald Trump, our former president, presently a candidate for the presidency, and the United States. This prosecution that is going forward now in the U.S. District Court in the District of Columbia based upon 4 charges brought against him by the special counsel for the Department of Justice, special counsel Jack Smith. We have talked a lot about that process. Suspended, not proceeded on, while the Supreme Court addresses issues related to the legitimacy, the rightness, the correctness of the charges against him, and specifically this major issue involving whether or not a president, a chief executive of our nation, is entitled to immunity from crimes committed in office. That's the question that the Supreme Court wrestled with, and yes, just last Monday, in what is arguably one of 2 major decisions issued by the Supreme Court that's going to change our lives, our livelihoods, and our nation, the United States Supreme Court issued a major opinion and found that there is indeed a presumptive immunity, a presumption of immunity that applies to a chief executive in connection with crimes that may have been committed in office. Because of the seriousness of that finding, we're going to spend a huge amount of time, especially in our first hour on this weekend broadcast, talking with you about exactly what the majority of the United States Supreme Court said, what the Chief Justice John Roberts wrote about, And then we're also going to talk about what the dissenters, three dissenters, said, two in particular, Sonia Sotomayor and Ketanji Brown Jackson, what they said about this issue of whether or not, under our Constitution, under our laws, under our system of the rule of law in America, for 248 years, there is indeed a notion in which someone, the President of the United States of America, is above the law. The Supreme Court, even while it's affirming that, yes, indeed, no one is above the law, has made a finding that indeed there are certain things carved out because of the nature of the presidency that require that when it comes to judicial adjudication, resolution of cases and crimes and charges, that indeed a president has immunities in some areas when it comes to criminal acts. And as we have spoken before on this broadcast and others, the perspective that I would offer to you is that that opinion issued by the United States Supreme Court just in the past week changes America. Changes America, and for that reason, we are going to spend a lot of time talking about exactly what the Chief Justice wrote, a couple of things about what one of the Associate Justices, named Clarence Thomas, also wrote about the very legitimacy of the special counsel statute, and then also focusing upon these dissenting opinions. And it is important for Americans to understand not only what our Supreme Court has done and said in detail because of the importance of this, but also to understand the countervailing, the opposite argument, which is articulated so very well by the dissenting opinions. We're going to spend a lot of time reading from the opinion so that you can hear what our justices have said on both sides of the decision and making some assessments on your own, of your own evaluation based upon what you hear, based upon what you can in fact consume at any time when it comes to reviewing this all-important opinion. We recall well that the Supreme Court, in the days just before its issuance of this major opinion in Trump versus United States, issued another opinion, a case called Loper Bright Enterprises, in which it basically changed the ways in which government interacts with courts and courts with government, changed the ways in which our administrative agencies operate, reversing 40 years of precedent when it comes to the appropriate deference given to agency officials who know what they're doing, the experts, the people who are experienced in doing this, and change that such that the judges now going forward have the exclusive capacity to make decisions in areas that, with respect, they do not know about. That decision, called Loper Bright Enterprises, issued just before this other opinion on presidential immunity, changes the way the government works. I would offer that the opinion issued by the Supreme Court in Trump versus United States affects to the detriment our Constitution and changes the very ways in which our Constitution is designed, that is, with checks and balances. I have thought a lot about this in the week or so since the Supreme Court issued this opinion, and I have questioned myself about whether or not I'm being hyperbolic. I'm being too extreme in my responding to this particular opinion. And even in preparing for this weekend's program, I revisited that issue as I put together some portions of the opinion which we will hear from this weekend. And I've decided that I am not being hyperbolic. You may have a different view about this, but the reality is that our Constitution was changed a week ago by the United States Supreme Court. And it is a Constitution that now advances in the wake of the exaltation of courts, in the wake of that Loper Bright Enterprises over the decisions of an executive branch, and now an imperial presidency that, as some of the dissenters indicate, have now reestablished something that we have not had in 248 years, and that is a king in America. That is not hyperbolic. And I would offer that the language that you're going to hear about today in our broadcast, specifically in this first hour, supports that notion. Again, you, as always, on the civic media broadcast stations, free to come to different conclusions. And I want to hear about those, and I want to hear about all your questions and comments about this assessment as we march through what the Supreme Court did a week ago in changing the very constitution of our nation, the very way in which we interact with government, and the very way in which our president now has capacities to do things in the nature of criminal conduct that he, one day she, never had before. James Madison, George Mason, other people, designers of our Constitution, never contemplated that this kind of thing would happen. Now it is a part of our landscape, of our fabric. And we will talk about that and describe in detail what it is the Supreme Court has done. In addition to issuing this major opinion, and as a part of our comprehensive review of those Supreme Court decisions, it is significant to note that in addition to Trump versus United States issued on Monday of last week, the Supreme Court also took care of two other decisions before it decided to go out of business, if you will, for at least a while. They're actually still there. They're still there handling cases during the summertime. And yes, building a docket for the next term, which is the 2024-2025 term. That begins in October of this year. But before they left, before they issued these final decisions, among those final decisions were two others. One of them is called Corner Post Incorporated versus Board of Governors of the Federal Reserve System. It has to do with an Administrative Procedures Act case, and specifically a claim with a timing of when this particular claim accrues under a particular statute, finding that a 6-year statute of limitations until the plaintiff is injured by a final agency action is what applies. And there you have another 6-3 opinion. Justices Barrett, Roberts, Thomas, Alito, Gorsuch, and Kavanaugh on the majority, establishing a specific rule when it comes to the timing of the filing of a complaint, opposed by Sotomayor and Kagan and Jackson on the dissenting side. Corner Post versus Board of Governors of the Federal Reserve System, having to do with forms of payments, debit cards, all sorts of financial transactions, the Federal Reserve Board, and issues about whether or not a 6-year statute of limitations is real or not under a particular statute. That case, Corner Post versus Board of Governors of the Federal Reserve System. And then another case that actually gives more attention to what the Supreme Court does, and that is Moody versus NetChoice. This is the other social media case. And there you have a 9-0 opinion saying that because the lower courts have not properly exposed and explored the particular First Amendment issues there, no decision there about that particular case, a 9-0 opinion, sending it back down to the circuit courts to decide about various issues there. When we return, we're going to be talking more about not just those cases, but specifically focusing in on Trump versus United States here on Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle. Thank you so much for joining me on our weekend broadcast, as we have in the past two broadcasts, and broadcasts even before then. We are talking once again about the United States Supreme Court as they issue their final decisions of this term before they begin to fill up their docket for the next term and entertain oral arguments in the fall of this year, and again next year at this time, issuing the next set of major opinions at this time of the year, focusing upon the most recent decisions issued just this past week, three of them in particular. This case involving a statute of limitations under the Administrative Procedures Act, And the second case involving social media, finding that the Florida and Texas statutes that require that social media platform providers moderate their own behavior when it comes to content moderation could not properly be decided. Why? According to the Supreme Court, because both of the lower courts, the circuit courts in the 11th Circuit and the 5th Circuit, failed to properly analyze the specific legislative enactments here under an appropriate First Amendment analysis. They send the cases back down to those circuit courts, perhaps to the trial courts as well, saying you've got to do a better job. Come back with it to us when you've resolved these issues under a First Amendment analysis. No clear statement by our Supreme Court about whether or not state legislatures can compel social media providers to regard their content moderation processes as subject to legislation, basically requiring that they explain every time they bring down a particular post for being the focus of misinformation or incendiary type information. That's what the legislation basically said. No resolution of that particular issue, that dispute, if you will, between states and the social media providers until the lower courts wrestle more directly with First Amendment issues. That case, once again, Moody versus Net Choice. The other one, Corner Post versus Board of Governors of the Federal Reserve System. The two other cases decided at the very end of this term. And then we turn, of course, to the principal focus of our discussion on Amicus, a law review of this weekend. And that is the case of Trump versus United States. As I indicated in our first segment in this first hour, it is a subject of an awful lot of focus, an awful lot of people on both sides of the political aisle looking at this opinion and scratching their heads. You may recall well that there was a time on this broadcast, a time on many broadcasts out there, television, radio, in the newsprint, all sorts of media outlets indicating that there is no issue here. There is no issue but that an executive of our nation, as understood under our Constitution, is indeed subject to the laws of our nation. And the notion, the idea that somehow a president could commit crimes in office and not be subject to prosecution for those is ridiculous, is crazy. It's basically contrary to the basic tenets of our Constitution. And indeed, for that very reason, I and many other people, much brighter, much more experienced than I, took the position early on that when the Supreme Court decided to take this case on, they were plainly going to articulate this view clearly, unequivocally, unanimously, that there is nothing to see here, that the President of the United States of America is not above the law, is subject to criminal prosecution, cannot commit crimes in office. And in fact, we saw during the course of the oral argument a lot of what results in the major Supreme Court opinion of just this past week. That is the Supreme Court, at least a majority of them, giving an awful lot of regard for this notion that is indeed ridiculous, that somehow our president can commit crimes in office and not be held responsible for them. We saw that in the oral argument. We're very concerned about it. And indeed, it shows up. It shows up in even a more robust nature in the opinion that the Supreme Court has issued. The majority opinion that I commend to all of you in terms of reading because of the significance of it to the future of our nation, not just in this political season, not just for the presidency as it begins a next term in January of 2025, but for the future of America. We know that in the end, the United States Supreme Court said this, and this comes, as do all of the other recitations this weekend, directly from the order, the opinion of the United States Supreme Court, issued by John Roberts, authored by him, joined in by the majority as well, and with, of course, two dissents, joined by three dissenters, and a couple of concurring opinions, which we will also talk about, coming from Justice Thomas and, very interestingly, from Justice Amy Coney Barrett, separating himself a bit from a key piece of this major order, which we will talk about as well. What, in the end, does the Supreme Court say definitively and clearly? It is stunning. It is shocking. The Supreme Court says this: we conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. That language should be chilling to all of us, at least with respect to the president's exercise of his core constitutional powers. This immunity must be absolute. And we'll talk about one specific incarnation of that ruling when it comes to the U.S. Department of Justice, which is perhaps the most significant thing that the Supreme Court says. As for his remaining official actions, Chief Justice Roberts writes, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute and instead whether a presumptive immunity is sufficient. And so the upshot of all of this is that there are some areas which we will discuss where a president is absolutely immune, no possibility of prosecution for crimes committed, and other areas where there is a presumption of that same kind of immunity that, yes, indeed, has got to be overcome by the government in its presentation of this case. Other aspects of this particular opinion, which we will focus on, are also about the specific ways in which this particular trial can, in fact, go ahead now in front of Judge Tanya Chutkan. She is the district court judge who now has this back on her docket for a trial, presumably sometime in the future. We'll talk about the timing of that in future broadcasts. But all of this premised upon a basic notion that is also set forth early in the opinion. This notion of a very muscular and very, very energetic, United States executive. Here's what the Chief Justice says. He says, the framers sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single constitutionally indispensable individual the ultimate authority that in respect to the other branches the Constitution divides among many. Now, he's acknowledging there plainly that we do have a tripartite Constitution, 3 branches of government, but note the muscularity of that description, that energy, that vigorous, decisive, speedy execution, which animates all that comes forward. That is a fundamental notion that's set forth in Justice Roberts' opinion here. That vigor is also described when he says this: the framers' design of the presidency did not envision a counterproductive burden on the vigor and energy of the executive. That notion of a very strong, arguably even stronger than the legislative branch, that also animates much of this. Then we go on to talk about presumptive immunity. And as our discussion continues, we'll hear from the Chief Justice and the majority about what exactly that means and how it implicates the future of our nation, right here on Amicus, a Law Review. This is Amicus, a law review. My name, Jim Santelle. I'm your host this hour and next hour as well. In our second hour, taking your phone calls, your inquiries, your questions about the subject matter of our discussion this morning. That number, 844-967-2789. Taking all of those inquiries in the wake of our broad and comprehensive review, not only of previous decisions, but on this broadcast, a very exhaustive, in-depth exposition of what our Supreme Court said about this all-important case, Trump versus United States of America, that changes who we are, changes how our government works, changes the very fabric of our Constitution and the life of our nation as we go forward. Talking about this notion established by the Supreme Court now a week ago, that there is a presumptive immunity, presumed immune is the presidency of the United States of America. The Chief Justice writing this, taking into account these considerations, and once again, he is talking about a very energetic, a vigorous, a muscular, decisive, and speedy executive branch that perhaps gives more focus to and more strength to the executive branch than our Constitution authors anticipated. Remember that the first article of the Constitution, plainly our founders anticipated that it would be the legislature that is the beefy, very vigorous and decisive entity. Now, according to the Supreme Court, it's not that. It is the executive branch. And oh, by the way, according to the Supreme Court in this term as well, it's also the courts which have this major role coming from the third article of the Constitution. They also have this huge role in this case, identifying for the first time in our nation's history an immunity that attaches to our chief executive for crimes, an executive who now, contrary to what the Supreme Court says in its majority opinion, certainly seems to be above the law. And indeed, that is exactly what the Supreme Court establishes when the Chief Justice says, taking into account these considerations of this muscular and very active and vigorous executive, we conclude, he says, that the separation of powers principles explicated in our precedent necessitates at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. A lot of words there. Basically, the assumption going in is that if there are things within the scope of official responsibilities, there's a presumption that that president, whoever he or she may be, is immune from prosecution. Such an immunity, the Chief Justice goes on to write, is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. Note that right now. Note that Sonia Sotomayor notes that in her dissent and asks whether or not there should, in fact, be some caution by our chief executive. Indeed, there should. The court goes on to say, if presumptive protection for the president is necessary to enable the effective discharge of his powers when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge and try and imprison the president himself for his official actions. And here we go. The court says, at a minimum, the president must therefore be immune from prosecution for an official act, listen to this, unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Note that once again as we talk about the dissents a little later in our broadcast. And note the significance of that. Not only is there a presumption of immunity, but it is now the obligation, Jack Smith and presumably future prosecutors, that when it comes to determining whether or not there is an immunity that attaches at all, it is the government's obligation to show that the charges that are brought in this particular case present no dangers of intrusion on the authority and functions of the executive branch. Wonder out loud whether that can ever be the case. It imposes a burden upon the prosecution that we have never heard from before in 250 years of history, and that now, according to the Supreme Court, is also going to be a part not only of this particular trial, but other trials down the road. The court does go to great length to say, from the pen of the Chief Justice, that as for a president's unofficial acts, that is, things done presumably in his or her personal capacity, as it was discussed during the oral argument, there is no immunity, and describes the principles set out in a case called Clinton versus Jones, all those kinds of things. The separation of powers, the Chief Justice says, do not bar a prosecution predicated on the president's unofficial acts. And the concern there, of course, is that by virtue of the definition given to all of this, it is difficult, if not impossible, to identify what those unofficial acts would be that would provide for an unfettered access to a prosecution on those unofficial acts. All of that a part of the oral argument, now a part of the official opinion here. And so in the wake of those fundamental notions, an aggressive, a muscular, a very vigorous executive branch identified arguably more powerful than the other two, contrary to the way that our Constitution was set up, and this notion that the presumption applies across the board to a president and must be affirmatively disproved by a prosecution in a criminal setting, all of that leads the court to say, we're now going to offer some guidance about how you implement all of this. The Chief Justice says, we offer guidance on these issues. And here we go. Here we go when it comes to understanding exactly how this plays out in 5 different components of the indictment against Donald Trump. This is the introductory language in the opinion. Certain allegations, such as those involving Trump's discussions with the acting attorney general, which again form a core piece of the indictment, those are readily categorized in light of the nature of the president's official relationship to the office held by that individual. That's introductory language, but as we will hear and note in just a moment or so, what the justices are saying there is that as to those communications, as to those engagements between the chief executive and the Department of Justice, those are absolutely immune. Don't touch those at all. No presumptive immunity. Those are off the table completely. And then with respect to 4 other categories involving the vice president, fake electors, others involved in this scheme to undermine our 2020 election results, and communications on January 6th, as to all those other things, this is what the Chief Justice writes. He says, other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. Although we identify several considerations pertinent to classifying those allegations and determining whether or not they subject to the immunity, that analysis ultimately is left best to the lower courts to perform in the first instance. That, again, an indication that all of this coming back to the trial court to sort out these new principles, with the exception of engagements and communications with the Department of Justice. There is more when it comes to the way that trial will be conducted, and it is sort of in the initial portions of this opinion as well, and it has to do with another change in the way that criminal cases will be prosecuted when they involve the President of the United States of America. As we've talked on a routine basis on this broadcast, it is a key part of any criminal prosecution that the government, which has the burden of proof, absolutely remains with the government at all time, beyond a reasonable doubt. All of that also requires that the prosecution show intent and purpose and often motive as well. Here, the Supreme Court says that particular element, the motive element, that in fact is not a part of the prosecution. And so the court says this: in dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry, the Chief Justice writes, would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that immunity seeks to protect. What he's saying, in other words, is you can't inquire into the reasons why the defendant, in this case Donald Trump, did what he did. No motive, Jack Smith, can be introduced in the course of the trial itself. No look at the proper motive, the animation, the purpose behind doing that, contrary to the way that every single criminal prosecution is pursued in America and beyond. Then let's get into the specifics of these 5 different areas: the Department of Justice, the Vice President, the fake electors, others involved in this scheme as alleged, and communications on January 6th in particular. The court goes on to say that investigations and prosecutorial decision-making is the special province of the executive branch. They get that particular aspect right. For this reason, the Chief Justice says, Trump's threatened removal of the acting attorney general implicates conclusive and preclusive presidential authority. This is going in the wrong direction. As we have explained, he goes on to say, the president's power to remove executive officers of the United States whom he has appointed may not be regulated by Congress or reviewed by the court. The president's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the attorney general, in their most important duties. That is stunning language coming from the Supreme Court. And here is the lesson. If it's not clear up to now, here is the absolute immunity that a president now has in connection with committing crimes when it comes to engagements with the Department of Justice. The indictment's allegations, in this case, the justice is talking about, that the requested investigations were shams or proposed for an improper purpose, do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials. The president cannot be prosecuted for conduct within his exclusive constitutional authority. Trump is therefore, hold on, absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. Let me read that again. The defendant, Donald Trump, is therefore absolutely immune, cannot prosecute, cannot be found guilty of proven offense conduct, absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. That is taken off. That is off the table, and not only for this trial, but down the road, any engagement of a criminal nature, incurring Justice Department officials to undergo and undertake inappropriate, illegal, unlawful investigations, do other things under the authority of the Attorney General and the many investigative units that collectively comprise the Department of Justice, directing the Attorney General to engage in criminal conduct, absolute immunity. Can't touch that. That is as a result of what the Supreme Court has written just this past week. Then we get on to the other areas involving, again, the vice president. A discussion here as well about the relationship between the vice president and the president. Arguably the good news here is that there's no absolute immunity, but presumptive immunity for all of these other things, including things said to the vice president. Whenever the vice president and the president discuss their official responsibilities, they engage in official conduct. And that certainly is not disputable. That's what the Supreme Court says. Presiding over the January 6th certification proceeding at which members of Congress count the electoral votes is constitutional and statutory authority of the vice president. The question then, according to the Chief Justice, is whether that presumption of immunity is rebutted under the circumstances. And stunningly, the Supreme Court says the president may frequently rely on the vice president in his capacity as president of the Senate to advance the president's agenda in Congress. When the Senate is closed and closely divided, for instance, the vice president has to act. But in the end, applying a criminal prohibition to the president's conversations discussing such matters with the vice president, even though they concern his role as president of the Senate, may well hinder the president's ability to perform his constitutional functions. And therefore, we've got this lesson. It is ultimately the government's burden to rebut the presumption of immunity when it comes to those engagements, even if they are criminal in nature. We therefore remand to the district court to assess in the first instance, with appropriate input from the parties, whether a prosecution involving Trump's alleged attempts to influence the vice president's oversight of the certification proceeding in his capacity as president of the Senate would pose any dangers of intrusion on the authority and functions of the executive branch. Stunning language. When we return, more focus on that and also the focus on the other areas where presumptive immunity now applies as to the crimes of any sitting or future president of the United States of America. This is Amicus, a law review. My name is Jim Santelle. We are marching through some of the major language written by the Chief Justice of the Supreme Court and issued to America just this past week, establishing this notion that with respect to the criminal conduct of a sitting and future president, there is immunity that attaches to those. Absolute immunity for engagements with the Department of Justice, permission to commit crimes when it comes to engagements with the United States Department of Justice, and as to even things related to vice presidential communications, a presumption of immunity that needs to be rebutted and overcome by a prosecutor. And so the Supreme Court telling us then once again that on remand to the district court, that judge, Tanya Chutkan's got to figure this all out, and telling her in particular that Trump's attempts to influence the vice president's oversight of the certification proceeding in his capacity as president of the Senate has to determine whether that would pose any dangers of intrusion on the authority and functions of the executive branch. Note that once again for the dissents coming up as we discuss those as well, finding in the end that these are difficult questions, and indeed they should not be, but for the Supreme Court they are, and finding that with respect to the vice president, not absolute immunity, but a presumption of immunity. Sort that out, lower court. And then the court goes on to say that the remaining allegations cover a broad range of conduct, and indeed they do. They focus on the fake electors scheme. They focus on other engagements with government officials, with others involved in this attempt to undermine the 2020 election, and then indeed communications on January 6th. All of that, the Supreme Court giving basically a roadmap for how the court should resolve these things. And as to all of those engagements, presumptions of immunity attach to be overcome, if at all, by the prosecution, and establishing as a matter of law now that in the case of fake electors and these other situations, that the government is obliged to show that the immunity does not attach if indeed they can establish that it will not somehow intrude into this very muscular and energetic executive that they are now describing. The president's broad power, the court says, to speak on matters of public concern does not exclude his public communications regarding the fairness and integrity of federal elections simply because he is running for re-election. And that certainly is the case. Similarly, the president may speak on and discuss such matters with state officials, even when no specific federal responsibility requires his communication, to encourage them to act in a manner that promotes the president's view of the public good. The government, however, of course, articulates an allegation in its indictment that there is an extent to which that can go too far, and criminal advocacy for criminal conduct is that bridge too far. In the end, the Supreme Court says we're not going to decide that. Determining whose characterization may be correct between the defense characterization and the government prosecution, and with respect to which conduct requires a close analysis of the indictment's extensive and interrelated allegations, again, having to do with fake electors and other people communications. Unlike Trump's alleged interactions with the Justice Department, the Chief Justice writes, and there again, what is the rule there? Absolute immunity when it comes to the Justice Department. This alleged conduct cannot be neatly categorized as falling within a particular presidential function. Really? If indeed the government is in fact victimized by attempts at criminal conduct when it comes to the operation of government, we can't identify that as criminal behavior. The necessary analysis, the Chief Justice goes on to say, is instead fact-specific, requiring assessment of numerous alleged interactions with a wide variety of state officials and private persons, and the parties' brief comments at oral argument indicate that they starkly disagree on the characterization of these allegations. Yes, indeed, Mr. Chief Justice, that's what the trial is all about. These concerns we noted at the outset, the expedition of this case, the lack of factual analysis by the lower courts, the absence of persistent briefing by the parties, thus become more prominent. He is complaining there about the fact that the lower courts did not properly wrestle with the fine issues that he is now defining for the first time in our nation's history. We accordingly remand to the district court to determine in the first instance, with the benefit of briefing, that we lack whether Trump's conduct in all these areas qualifies as official or unofficial, whether or not presumptions of immunity do in fact apply, or whether somehow this can be categorized as outside that ambit and for that reason only subject to criminal prosecution. As to the public communications, the court goes on to say that the president, in fact, believes that he may, in fact, be advancing a public interest. Goes on to say he is even expected to comment on those matters of public concern that may not directly implicate the activities of the federal government. For this reason, most of the president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities. That's a way of saying to Judge Chutkan, you make the assumption that virtually all the things in these communicative pieces during the course of this conspiracy to undermine the 2020 election, to overturn the results of the votes in America, the communications on January 6th, assume going in, Tanya Chutkan, that all of those are within the perimeter of official responsibilities and therefore not subject to criminal prosecution. Knowing, he says, for instance, what else was said contemporaneous to the excerpted communications, or who else was involved in transmitting the electronic communications, organizing the rally, could be relevant to the classification of each communication. This necessarily fact-bound analysis is best performed by the district court. We therefore remand to determine in the first instance what is going on here. And beyond that, as we said, some major decisions about how evidence will be presented during the course of this trial. And here it is, very important to understand not only this, but something that one of the associate justices, Amy Coney Barrett, takes up in her concurring dissent, which we will get to in our second hour. The Supreme Court says this: the government does not dispute that if Trump is entitled to immunity for certain official acts, he may not be held criminally liable based on those acts. But it nevertheless contends that a jury could consider evidence concerning the president's official acts for the limited and specific purposes, and that such evidence would be admissible to prove, for example, knowledge or notice of the falsity of his election fraud claims. In other words, you got to be able to present evidence of what is official, what is in the ambit of things given to a president by the Constitution, to understand how those things are violated by the criminal law. The Supreme Court goes on to say this: we're not going to have that. The proposal threatens to eviscerate the immunity that we have recognized. In our second hour, more on what the Chief Justice says. We're going to hear also from the dissenters, and then take your phone calls at 844-967-2789 here on Amicus, a law review.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and I am Jim Santelle, your host for this, our second hour of our weekend broadcast, focusing on the law, government, and the aspiration for justice. In particular, in this weekend broadcast, spending a lot of time appropriately on this major opinion of the United States Supreme Court among about 58 or 59 that it issued in this past term. This one changing America. This one changing the Constitution. This one changing the way in which our three branches of government interact, identifying not just an energetic but a hugely powerful executive branch, a chief executive that can indeed commit crimes in office, presumptions of immunity that attach for conduct not only charged in this particular case against Donald Trump, but presumably down the road as well. And indeed, the Supreme Court talks about the legacy of its case, of its decision down the road as well, talking about the limitations also posed to the prosecution, saying that you can't explore the motive of the defendant, the president, the former president, during the course of the trial. You can't get to purpose or intent, can't do that. And in addition, you've got the obligation to show that your particular prosecution will not unduly burden the exercise of official executive responsibilities and duty. You've got to overcome the presumption of immunity during the course of your trial, something we've never done in 250 years of history. And also, you can't make reference to specific things that are related to official conduct that is authorized by the Constitution when you're trying to prove unofficial conduct or other things that are violative of the law. If official conduct for which the president is immune may be scrutinized to help secure his conviction, the Chief Justice writes, even on charges that purport to be based only on his unofficial conduct, the intended effect, the Supreme Court says, of immunity would be defeated. The president's immune conduct would be subject to examination by a jury on the basis of generally applicable criminal laws. Use of evidence about such conduct, even when an indictment alleges only unofficial conduct, would thereby heighten the prospect that the president's official decision-making would be distorted. And it goes on, allowing prosecutors to ask or suggest that the jury, the finders of fact in these cases, probe official acts for which the president is immune, would thus raise a unique risk that the jurors' deliberations would be prejudiced by their views of the president's policies and performances while in office. The prosaic tools on which the government would have courts rely are an inadequate safeguard against the peculiar constitutional concerns implicated in the prosecution of a former president. I've talked a lot about the cynicism and the contempt that at least one, if not two members of our Supreme Court have for the tools and mechanisms of criminal justice. Here it's articulated once again, referring to the basic trappings of jury instructions, of limiting instructions by a judge, of evidentiary rulings as prosaic tools in this particular criminal prosecution that apply to every other criminal prosecution in America, but will not apply here because they would limit the powers of this chief executive. The government asserts that the robust safeguards available in typical criminal prosecutions alleviate the need for the kinds of review that indeed the court is advocating for here. This coming out again from the opinion of the Supreme Court. And here again is the cynicism of the Chief Justice and the majority. The safeguards, which are a part of every criminal trial, though important, do not alleviate the need for pretrial review. They fail to address the fact that under our system of separated powers, criminal prohibitions cannot apply to certain presidential conduct to begin with. As we have explained, when the president acts pursuant to an exclusive constitutional power, Congress cannot, as a structural matter, regulate such actions, and courts cannot review them. And he is at least presumptively immune from prosecution for his other official conduct. All of that a part of the majority opinion. The court concludes in its majority opinion, again, says things about the cannibalization of the executive branch, all these terrible things that will happen if indeed the basic rules of law are applied to a presidency. Virtually every president, the court says, is criticized for insufficiently enforcing some aspect of federal law. An enterprising prosecutor and a new administration may assert that a previous president violated that broad statute. Without immunity, such types of prosecutions of ex-presidents could quickly become routine. The enfeebling of the presidency and our government that will result from such a cycle of factional strife is exactly what the framers intended to avoid. Just the opposite. Just the opposite. And indeed, the other problem with that fundamental notion articulated by Justice Alito and other justices during the oral argument is it assumes a cynicism, a contempt for the basic ways that we prosecute in America, that a grand jury has to make decisions about whether or not crimes have been committed, that prosecutors have got to be corrupt, that judges have got to be corrupt, that juries have got to be corrupt before all of this can happen. In the end, the Chief Justice says, the case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Our nation has never before needed an answer. Well, that's true. But in addressing that question today, unlike the political branches and the public at large, we cannot afford to fixate exclusively or even primarily on present exigencies. That's another way of saying we're not going to focus on the law here. We're not going to focus on the particular charges, which was also coming out of the mouths of the Supreme Court justices during the oral argument. They didn't want to talk about the specific claims, the allegations in the indictment against Donald Trump. Let's talk about broader issues here once again. That particular articulation from the oral argument is incarnated in the very opinion. In a case like this one, the Chief Justice goes on, focusing on transient results may have profound consequences for the separation of powers and the future of our republic. It is these enduring principles that guide our discussion in this case. The Chief Justice says, the president enjoys no immunity for his official acts, and not everything the president does is official. The president is not above the law, which again is true, but he inserts that inside a paragraph that basically takes it all back. Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution, and the system of separated powers designed by the framers has always demanded an energetic, independent executive. There it is once again, this superpowered, muscular executive branch that can basically do what it wants with impunity. That inside the law now of the United States of America. The president, therefore, may not be prosecuted for exercising core constitutional powers, and he is entitled at a minimum to a presumptive immunity from prosecution for all his official acts. That immunity applies equally to all occupants of the Oval Office, regardless of politics, policy, or party. The judgment of the Court of Appeals is reversed, sent back to the trial court for Judge Tanya Chutkan to figure all of this out based upon these brand new articulations of presumptive immunity, issues related to how evidence will be presented, the stripping of the capacity to describe motive and purpose and intent, the notion that the government now has got to establish that indeed the prosecution will somehow will not impinge upon the executive branch if indeed it is permitted to go ahead. All these kinds of things, and cannot make reference to official responsibilities in describing the difference between those and official crimes set forth in the indictment. All of that a part of the 43-page opinion that is now a part of the annals of the Supreme Court of the United States of America. I commend to your reading all of this. It is readable, and I've excerpted the principal key portions of what the Chief Justice has written, concurred in by all of the justices but three, and there are dissents as well. And we're going to talk about some of those concurring opinions. You've got one by Justice Thomas that regards the very appointment of the special counsel as unconstitutional. It is worth reading. It is worth dismissing as well because of its inherent incapacity to articulate a real principle. But it is there as well, concurring in the result, Justice Thomas, but saying that Jack Smith has no authority to do this at all, undermining the very constitutional trappings of the special counsel and the statutory authority given by the Congress, not only for this special counsel, but all the other special counsels we've heard about in recent times.
including that who is prosecuting the president's son right now, Hunter Biden, and others in this case. And then we also get the opinion of Associate Justice Amy Coney Barrett, and she picks up on this notion. And she specifically says that I disagree with the court when it comes to this new evidentiary rule that will attach to the trial in this case that says that the prosecution cannot talk about the official duties as established in the Constitution of the president, cannot talk about that, cannot raise those, cannot articulate what those are, define those when it comes to proving the unofficial acts which are a part of the indictment. She goes on to say that while she agrees with the dissent when it comes to this particular issue, she wants to explore this in greater detail. She says, excluding from trial any mention of the official act connected to a particular piece of criminal conduct would hamstring the prosecution. And here's the language that Amy Coney Barrett says articulates that separates her, Amy Coney Barrett, from the others in the majority. She says this: to make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo. The quid and the quo, she says, even if the quo, standing alone, could not be a basis for the president's criminal liability. I appreciate the court's concern that allowing into evidence official acts which the president cannot be held criminally responsible, that they may in fact prejudice the jury. But the rules of evidence are equipped to handle that concern on a case-by-case basis. She does not have the cynicism, not have the contempt that the others have for the basic trappings of trial. More importantly, she says, a trial court can exclude evidence of the president's protected conduct if its probative value is substantially outweighed by a danger of unfair prejudice or confusing the issues. That is the standard that applies in virtually every criminal trial, state or federal in nature. A balance in more likely to favor admitting evidence is much more compelling. That is Amy Coney Barrett, and she sees no depart from that familiar and time-tested procedure here, no reason to depart from any of that. When we come back, more discussion of Trump versus United States here on Amicus, a law review. This is Amicus, a law review. My name is Jim Santelle. We are talking all about, and yes, describing in great detail what the United States Supreme Court has said in this case, Trump versus United States. Also, in the remaining segments of this hour, the second portion of our broadcast, inviting, encouraging, soliciting your questions and your inquiries about the subject of our discussion today. And we're going to turn to the first of our callers right now. Thank you, Dana, for joining us from La Crosse. Your question, your inquiry, your comment about the United States Supreme Court and its decision finding that presidents are in fact immune from certain types of criminal conduct while in office.
Good morning, Jim. Happy We Don't Believe in Kings weekend.
Absolutely. A great way to describe it. One of our dissenters, we'll hear from her, basically says, yes, we now have kings. That's exactly your point, Dana, right? We're back to
to the king at the time of our independence 248 years ago.
This is just completely unexplainable. It's clear this court has an agenda, and I mean, Jim, they're just taking simple cases now and either rewriting law or just making up law out of them. So, what I'm calling about, I've been waiting a while to ask you this question.
Yes.
I'm not sure where I heard it. I don't know if maybe it was you or maybe it was like Tom Hartman, but I seem to remember a discussion at one time where there's a certain way of legislation that can be written
Mm-hmm.
where a provision or a classification of some sort can be inserted where the Supreme Court is not allowed to review this case. And if that is correct, is there any type of legislation that could come down the pike where Congress deems that indeed the president is subject to the same laws, processes, and penalties of regular Americans? This would not be reviewable by the Supreme Court. And then also something along the lines on what they did to the Chevron ruling. I think these are the two most
Absolutely
impactful rulings to come down, and they're going to change this country forever. I'll take your answer off the air, but I do just have a quick comment to our conservative friends out there. You guys know this is just completely wrong.
It has to be.
And you've learned this ever since you were in grade school. It
Right.
goes against everything this country is about. And I hope you really think about that come November. Thank you, Jim. Have a great weekend.
Dana, thank you so much for your comments. I concur in your assessment of the seriousness of this, the gravity of what may yet come. And let's talk about those processes that are out there. It is very interesting to note that there's already at least one member of our Congress who has sent a letter to his colleagues saying that I'm going to introduce some legislation to respond to this. Others also responding to this case involving Chevron, the Loper Bright Enterprises case from the previous Friday, indicating that agencies no longer have a right to claim some deference from the courts. All of this, and a couple of responses, Dana, to your very good thoughts about things that the Congress can do. Two of them come to mind. We've often talked, and it may have been me, Dana, may have been Tom Hartman as well, maybe other people have talked about legislative fixes, right? The Congress can, in fact, pass laws. We've talked about this a lot. The Congress can in fact, fix the cases involving voting rights, where the Supreme Court has stripped back many of the things in the Voting Rights Act. The Congress can, in fact, fix issues related to environmental decisions they've made. All kinds of things can happen. And yes, indeed, they can do this kind of thing. They can also, and this is the second portion of this, we know that yes, a lot of the jurisdiction of a Supreme Court is set forth in the Constitution. Yes, it is in the third article. The third article of the Constitution. That is not insignificant. That it's number 3. It's not number 1, not number 2. It's number 3. It's also established there, but the Supreme Court is also subject to limits on its jurisdiction by the Congress. And indeed, one of the very first things that the very first Congress did was establish the Judiciary Act of 1789, establishing jurisdiction, things that the Supreme Court can and cannot do. Can they do that again? Sure they can. They can describe areas of expertise that the Supreme Court has, and also exhibit areas, illustrate and expose areas where the Supreme Court does not have that expertise, and limit their capacity to play around in those areas. The Supreme Court has done it to itself in deciding, for example, that it's not going to review cases involving political gerrymandering. A case where the Supreme Court has itself decided we're not going to play in that particular sandbox. The legislature can do the same thing. It can not only fix these kinds of things, it can establish legislatively that no one in the United States government, no official, is immune from criminal conduct. You can make that statement as a resolution of the Congress, put it in legislation, and set it forth there. And you can also limit the jurisdiction of the court if you choose to do that. We will see what happens, but Dana, your suggestions are among the remedies, which we always insist on talking about here, right, on this broadcast and others. What do you do in response to something like that? Well,
Now is the time, once again, to write your legislators and say that as the Supreme Court goes into its summer period here, not a hiatus, but no longer issuing these opinions, now is the time to write your elected representatives, even local representatives, county representatives, state representatives, and tell them how outraged you are by this rescission of the fundamental trappings of our laws, as Dana, as you've indicated, the fundamental rescission of structures of our government, and we want you to change it. And the Congress can do it. Not to say that that would not be subject to further challenge. Absolutely, we'll go back into court, back to a district court. But all of this subject to an awful lot of legislative action that could in fact happen. One more comment that also comes to mind, Dana. Some awful good people out there are saying, that this will not stand, that it cannot stand. It's like Plessy versus Ferguson. It's like Dred Scott. It's like Korematsu, the case that basically confirmed that indeed a president has the right to inter members, citizens of our nation because of their ancestry. All those kinds of things overturned. An awful lot of people saying that this will necessarily be overturned. It should be overturned. It should be overturned next week. But it may not happen right away. Why? Because you still have to have a case or controversy out there. You still have to have a capacity, some standing. And you've got to have some other situation where perhaps a future president is charged with crimes where the issue would come up once again. Maybe there's a civil aspect of this that could be decided. Maybe the Supreme Court, as it will in some other cases, announce by a footnote in other ways that it no longer follows Trump versus the United States. We look forward to that time. And we look forward to the time when legislators act, when people act, and indeed when we get to the dissenters, which we will get to in this hour of our broadcast, when we get to the dissenters, an invocation, a call to arms, to action, to advocacy, arms in the nature of public dispute and public advocacy for the overturning and the dispute with what this order is all about. That's what one of the dissenters specifically alleges. And in that context, as we begin to talk about the dissenters and also take more callers in our next segment, note that the majority of the Supreme Court also dismisses the dissenters and those who would say otherwise as being striking a tone of chilling doom, wholly disproportionate to what the court actually does today. That's the Chief Justice of the Supreme Court saying, don't be so concerned about this, Dana. Don't be so concerned about this. Do not rise up. Nothing about this is all that big a deal. Take just the opposite view. And we'll take more callers right after this here on Amicus, a law review.
This is Amicus, a law review. My name, Jim Santelle. These are final segments of this second hour, but taking your phone calls, your inquiries, your questions, your comments about the subject matter of our syllabus today, focusing on this major case involving the presidency and the future of America. This decision by the United States Supreme Court that under certain circumstances, the president is absolutely immune from criminal prosecution, other cases in which he is presumptively immune, requiring the government to show that somehow a prosecution would not impact the legitimacy, the strength, the vigor of an executive branch. All of that set forth in the majority opinion. We're going to spend some time, in addition to taking your inquiries, your calls as well. We're going to spend some time talking about the dissenting responses to that. They are compelling. And like the majority opinion, which I commend to your reading, I commend to your reading as well the dissenting opinions written by Justice Sotomayor and Justice Ketanji Brown Jackson. 30 pages, 22 pages, 52 pages altogether, about 43 pages. If you include Amy Coney Barrett's 7-page concurrence, you've got about 50 pages on both sides of this issue. Amy Coney Barrett, very significantly staking out her own ground in this term of the Supreme Court, parting more and more with the majority, and as to an evidentiary matter, saying, no, the prosecutor has got to be able to, during the course of this trial, present evidence of official conduct and official responsibility under the Constitution in order to establish the ways in which those conduct exercises were violated under the indictment. Always appreciating your phone calls at 844-967-2789. Promised those in the past. We'll continue with those, not only in the remaining time this segment, next segment, but also in our future broadcasts as well. Gene from Eau Claire, appreciate, Gene, you're calling in to express your view, your question, your comment, your observation.
Well, I'm calling with a comment, and I want to thank you from the bottom of my heart, all of the great things that you've given us every single weekend. Thank you so much for your service. To me, this has been an attack on all of us in the United States when we watched what happened on January 6th. Also, the things that happened with Trump, Russia, documents, and all the things, our security, our national security, our homeland security, and then to have these justices abuse their power, putting in new restrictions and things to keep us safe. Who can protect us, Jim? How do we get protections for all of us, regardless of party, as Americans who believe in the rule of law?
Where does that come from, right, Gene? Your question is not just rhetorical, it's practical. And I appreciate so much you're raising that question. What can you do about these kinds of things? Well, in response to Dana previously, we talked about the capacity that all Americans have in America under the First Amendment, under the general principles of our Constitution, to advocate for change. I've said this before. I know it sounds old school, but getting out a letter, a piece of letterhead, an envelope, a stamp affixed to that envelope, and send a letter to the Chief Justice. It doesn't have to be as extensive as this exposition has been on this broadcast. Pull out some language that I've identified here and tell the Chief Justice, tell other members of the Supreme Court how much you object to what they're doing here, undermining exactly, Gene, what you've just described as the basic tenets of our republic, and talking about the consequences of what may happen here. That's one thing you can do. The other thing that your very good comment, Gene, your question prompts me to think about is something else we reported here on this broadcast many, many months ago, and that is in Israel, long before the present war in Gaza involving Hamas and the Israelis. Long before that, you may recall that in Israel there was a proposal by the Prime Minister Netanyahu to limit the powers of the judiciary in that nation. And what did the members of the citizens, the residents of Israel do? They shut the country down over that. They took to the streets. Everybody, academicians, architects, educators, medical people, broadcasters, everyone got out into the streets and said, we're not going to take this. We're not going to permit this to happen. They shut down the airports. They shut down the basic trappings
of institutions there in Israel because they were so angry about what Netanyahu was proposing. In the end, the Supreme Court there, yes, ruled that what he was proposing was unconstitutional. But that's the kind of thing that I would offer we need to do. Nothing violent, of course. We're not advocating for that, but protests. America should be in the streets about these kinds of things, advocating for change, whether it is the kind of legislative change that we talked about before, advocating for a rescission of this opinion as soon as possible, explaining to people in our schools about why it is now we have to teach civics differently, because indeed there is now a muscular and this over-the-top executive that is immune from prosecution for crimes, and immunity that attaches to every other person in America, but not the president, because of what Chief Justice John Roberts has said just last week. That is a stunning development in the history of America. It comes at a time when we celebrate nearly our 250th anniversary. All the more reason for Americans to get out there and let people know about the outrage of this, let them know about the consequences of this, which are also the focus of the dissents in this case. And Gene, appreciate so much your comment and your inquiry, your advocacy also to do something, perhaps as the Israeli citizenry did a number of years ago, at least to let our government know that we oppose this kind of thing. We oppose the rescission of our Constitution. There are legislators at the federal level, the state level, the county level, the municipal level who are equally outraged, and I would offer that there are views on both sides of the political aisle about this case that condemn it and that say that it cannot be a part of our jurisprudence, that it is wrong. Among the people who say that so clearly, if you want to also include in your letters, your advocacy out there in America, commend very much the dissenting opinions from Justice Sotomayor and Ketanji Brown Jackson, with whom Justice Elena Kagan concurs. Here's what Justice Sotomayor says. She says today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. That's the change in our Constitution. It makes a mockery of the principle, she says, foundational to our Constitution and system of government, that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity asked for and more, because our Constitution does not shield a former president from answering for criminal and treasonous acts. I dissent. There is more in her absolutely articulate and compelling dissent in this case. She focuses upon the fact that there's no history to support this. She says the historical evidence reinforces that from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. The majority fails to recognize or grapple with the lack of historical evidence for its new immunity, indeed creating something out of whole cloth. With nothing more on its side of the ledger, the most the majority can do, she's talking about the Chief Justice and the other five, the most they can do is claim that the historical evidence is a wash. Yet the court has described only the evidence regarding the president's immunity from damages liability as fragmentary, and goes on to say the majority ignores the very compelling nature of history in all of this case, and then goes on to take on many other issues in the majority, including this notion that there would be an intrusion into the presidency, this strength, this very muscular, this very powerful intrusion, explaining that in the end, majority it describes this intrusion as being too much. The dissenting opinion here from Justice Sotomayor says, when presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient hardly matters. She says this description you're describing, distinction between the two, doesn't make a difference. Feel free to disregard all that. And here she goes, and it makes the point very clear. Maybe some future opinion, she writes, of this court will decide that presumptive immunity is sufficient and replace the majority's ironclad presumption with one that makes the difference between presumptive and absolute immunity meaningful. Today's court, however, has replaced a presumption of equality before the law with a presumption that the president is above the law for all his official acts. Strong words in response to a very strong and very flawed opinion by our majority. Appreciate, as always, your calls on this broadcast. Appreciating, Joe, you're calling in from Madison right now with your comment, your question, your inquiry about what's going on in America.
Thanks, Jim. Absolutely superlative. I really have appreciated the last several shows, and particularly this one. I'm not sure if you had gone over this or not, but I had three quick questions.
Yes.
First off, I was struck by the dissenters' language that was used, which really says our country, I mean, you could paraphrase, our country is on a precipice. We don't have a democracy, basically, if this goes through. I'm kind of interested in your reaction to this. That is not a collegial way of working things through. I mean, it was really in your face. This cannot keep going forward. I'm interested in your reaction to that as a prosecutor and someone very involved in the judicial system. I also had a second question. I don't quite understand, with this presumption of immunity, does this mean that impeachment is now off the table? If the president murdered someone on Fifth Avenue, does this mean that that person cannot be impeached? They can only be not indicted? And then the last thing I wanted to ask was, Dana was talking about the language of, we now have kings again. In a certain way, it's even worse because, as I understand it, with constitutional monarchies, it's a constitutional monarchy, meaning that they still have a parliamentary system that holds a check on the power of the executive / the king, if you will. I'd be interested in your reactions to that, too. Thanks a lot, Jim. I really appreciate it.
Absolutely, Joe. Lots of good things to unpack there. Indeed, the justices on the other side, the three, talk about exactly that kind of thing. I commend your attention, as you've already read them, but I commend the attention of all of our listeners to exactly what it is you are describing here. Let's look at a little bit of what the Associate Justice Sotomayor says in connection with that country on a precipice type situation. Indeed, it could well be. Here's what Sonia Sotomayor says in the wake of many, many other things, some of which we'll discuss today, perhaps in future shows as well. She says, the majority's single-minded fixation on the president's need for boldness and dispatch ignores the countervailing need for accountability and restraint. The framers were not so single-minded. In the Federalist Papers, she says, after endeavoring to show that the executive, designed by the Constitution, combines all the requisites to energy, Alexander Hamilton asked a separate, equally important question. Does it also combine the requisites to safety? In a Republican sense, a due dependence on the people, a due responsibility? The answer was yes, based in part upon the president's vulnerability to prosecution in the common course of law. The answer after today, she says, is no. And here she concludes her 30-page, very compelling opinion. Never in the history, this is the precipice point, Joe, never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide by will not provide a backstop. I commend to you all of Justice Sotomayor's opinion, and then also the one that has not gotten quite as much attention, and that is the equally compelling dissent by Justice Ketanji Brown Jackson. Justice Sotomayor spends a lot of time talking about the practical implications of all of this, and Ketanji Brown Jackson talks, Joe, about this larger issue, the impact upon the future, and along the way, the consequences of what we are hearing today. She says, I will highlight just two observations about the results that follow from this paradigm shift. She says, first, by changing the accountability paradigm in this fashion, the court has unilaterally altered the balance of power between the three coordinate branches of our government as it relates to the rule of law, aggrandizing power in the judiciary and the executive to the detriment of Congress. That's exactly what we were talking about earlier. This highly, highly important notion that balance in government is now imbalanced. Second, she says, the majority's new presidential accountability model undermines the constraints of the law as a deterrent for future presidents who might otherwise abuse their power to the detriment of us all. More here on Amicus, a law review from the dissenters
as our broadcast continues here on the broadcast stations of Civic Media. This is Jim Santelle. I am the host of this final segment of our weekend broadcast, Amicus, a Law Review, talking with you, talking with our listening audience about the significance of this major opinion coming out of the Supreme Court in its last announcement of the 60 cases on its docket in this term before it continues to address future cases in the next term, talking in particular about these very compelling dissents by Ketanji Brown Jackson and Sonia Sotomayor. Let's hear from them a little bit more. Ketanji Brown Jackson focusing upon the future of our nation. As Joe indicated previously, the country on a precipice. And what are the consequences of all this? Well, Ketanji Brown Jackson talks just about that. She says if the structural consequences of today's paradigm shift mark a step in the wrong direction, then the practical consequences are a 5-alarm fire that threatens to consume democratic self-governance and the normal operations of our government. The majority shoos away this possibility. But Justice Sotomayor makes the point plain, and I will not belabor it. Here, I will merely observe that from a theoretical perspective, philosophers have long considered deterrence, which we've talked a lot about on this broadcast, to be a key justification for adopting and maintaining systems that ensure accountability for criminal conduct. For that same reason, she says, some commentators also maintain that decreasing the certainty of accountability for wrongful acts at least arguably reduces incentives to follow the law. So she says this. One might ask, what remains of accountability for presidents under the law in the wake of what the majority has done? With today's paradigm shift, the majority leaves in place only the chance that this court might someday determine that the criminal conduct in question was an unofficial act, or that the government will somehow rebut the presumption of immunity that applies to a president's official acts such that criminal consequences might attach. But with the parameters of official and unofficial conduct unknown, again underscoring this made-up diversity of standards here, I think it is highly unlikely the sitting president would feel constrained by these remote possibilities. She goes on to say, as a part of her dissent, of course, that she disagrees with the majority in a major way. The court has now declared for the first time in history that the most powerful official in the United States can, under circumstances yet to be determined, become a law unto himself. As we enter this uncharted territory, this is Justice Ketanji Brown Jackson writing, the people in their wisdom will need to remain ever vigilant, ever attentive, consistently fulfilling their established role in our constitutional democracy, and thus collectively serving as the ultimate safeguard against any chaos spawned by the court's decision. For like our democracy, Ketanji Brown Jackson writes, our Constitution is the creature of their will and lives only by their will. For my part, she says, I simply cannot abide the majority's senseless disregarding of a model of accountability for criminal acts that treats every citizen of this country as being equally subject to law as the law requires. That core principle, she says, has long prevented our nation from devolving into despotism. That's what she is concerned about. Yet the court now opts to let down the guardrails of the law for one extremely powerful category of citizen, any future president who has the will to flout Congress's established boundaries. And indeed, Sonia Sotomayor rings the same bell. In her dissent, also commended for your reading, she says this: looking beyond the fate of this particular prosecution, the consequences of today's decision are stark. The court effectively creates a law-free zone around the president, exactly what Ketanji Brown Jackson is describing, effectively creating a law-free zone and upsetting the status quo that has existed since the founding. This new official act's immunity now lies around about like a loaded weapon. That's what she is describing for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. And interestingly, she cites Korematsu for that notion as an inappropriate expression and execution of executive authority. She goes on to say this: the President of the United States is the most powerful person in our country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. And here are the questions that she now asks, rhetorical but real. She asks this: orders the Navy SEALs Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune. Immune. She goes on to say this: let the president violate the law. Let him exploit the trappings of his office for his personal gain. Let him use his official power for evil ends, because if he knew that he may one day face liability for breaking the law, he may not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmares, Sonia Sotomayor continues, even if these nightmares never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. The majority's single-minded fixation, she goes on to say, on the president's need for boldness and dispatch ignores the countervailing need for accountability and restraint, exactly what Ketanji Brown Jackson, her colleague, also notes in her very compelling dissent. The framers were not so single-minded. The Federalist Papers, after endeavoring to show that the executive designed the Constitution, requires all these exigencies, all the energy. Never in our history of the Republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of the office misuses official power for personal gain, the criminal law that the rest of us must abide by will not provide that backstop. Repeating that important language from Sonia Sotomayor for a second time because of its compelling nature. And again, we have Ketanji Brown Jackson in her final opinion, noting once again the vision of our founding fathers, no longer embraced by majority here, that abandons our basic trappings of a tripartite form of government where checks and balances are in place, where indeed no one is above the law. I commend, as I said before, to your reading on this time when we celebrate the 248th anniversary of our nation, the reading of these opinions. Take a look at the majority opinion. Read more than I have read. Read the dissents and adjust for yourself the importance of this opinion as we ponder together on this broadcast and others the future of our nation. Inviting you back again next week for more discussion of other issues in the rule of law and justice and the delivery of justice for our United States of America. Have a good weekend, everybody.